Good morning, and welcome to News Without Prejudice. I've got with me here today, John.
That's me.
How are you doing today?
I'm doing fantastic. We've got a big story that actually just dropped yesterday in regards to Mr. Kilmar Armando Abrego Garcia from the United States to El Salvador. Lindsay, what's going on?
Yeah, so we've talked about this story a little bit so far in our News Without Prejudice. It's just chaos. Mr. Abrego Garcia was deported back to El Salvador, where he originally was born, even though there's a immigration judge's court order from 2019 that he should not be deported out of this country back to El Salvador.
Yes.
And so finally, the government admitted that it was a mistake. And what's the big news, John?
Yesterday, April 10th, 2025, the Supreme Court, in a unanimous 9-0 decision, decided that Mr. Garcia should be returned to the United States, specifically that the federal government should facilitate and effectuate the return of Mr. Garcia. I think there's the big thing to look at here is that the federal government admitted that his removal was an administrative error and then argued before the lesser courts that he basically could not be returned because now he was in El Salvadorian custody. Which is a very dubious prospect because it is very routine for ICE and other federal immigration law enforcement officials to return individuals deported or removed in error, as occasionally happens in a system this large. Under the first Trump administration, under Biden, under Obama, under Bush, it is very easy to have return deportation flights meet back in the United States. But I want to be clear, this is the federal government and the Department of Justice attempting to argue that the courts do not have jurisdiction.
Yeah.
They initially put up they were splitting hairs, like initially before Judge Boasberg, they were like, well, this is state secrets, so you can't know anything. And even if you can't know anything, then he's out of our reach. And even if he's not out of our reach, then we can deport whoever we want. And so it was sort of just a cavalcade of continuing.
Press Secretary Caroline Leavitt, she said, I love this quote so much. We suggest the judge contact President Bukele because we are unaware of the judge having jurisdiction or authority over the country of El Salvador.
Yes. Well, the problem with that is that the federal government has jurisdiction over the actions of the federal government. And as far as we know, the federal government is paying El Salvador to contain in CCOT, the Terrorism Confinement Center. President Bukele has described himself as the world's coolest dictator, which is
just mind-blowing.
Which is very cool. On Friday, April 4th,
cool.
To be clear, what is unusual about this case is that the federal government brought no factual or legal assertions to defend themselves.
Yes.
So the prosecutors just showed up and said,
he's a gang member.
Yeah, exactly.
That's why we deported him.
They actually used his proof of being a gang member. He has no criminal record. Mr. Garcia has no criminal record. And in initial filings, the federal government said that his lack of criminal history was proof of criminality.
Huh?
Yeah, that he was so dangerous that he had no criminal record. So that's
what I called an argument, folks.
Yes. Getting to the matter of the issue at hand, the federal government or the Supreme Court released an administrative order 9-0 unanimous. It is very difficult to get Clarence Thomas to say, hold on. And it was only about a page and a half long.
I was surprised by how short it was.
Yeah, the Supreme Court favors brevity whenever possible.
Understandable.
And I'm going to read an relevant part from the unanimous court decision. Quote, the application is granted in part and denied in part subject to the discretion of this order. Due to the administrative stay issued by the Chief Justice in reference to an order, I believe, on April 8th by Justice Roberts, the deadline imposed by the district court has now passed. To that extent, the government's emergency application is effectively granted in part, and the deadline in the challenge order is no longer effective. The rest of the district court's order remains in effect but requires clarification on remand. So this is not unusual that the Supreme Court gave no logistical guidance on when the gentleman should be returned or what facilitate should mean. This is an impulse we see from higher courts. The trial courts or lower courts generally are more familiar with the facts of the matter. And so the Supreme Court will do everything it can not to wade into the how, when, or what or whys unless it absolutely has to. So there's like this sort of cultural restraint. It'll kick the matter back to the lower courts, and the lower courts will weigh in more specifically. And that's actually what's happened. We actually have some motions that have been filed since the Supreme Court's order yesterday, just this morning in D.C. I continue. The district court should clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. For its part, the government should be prepared to share what it can concerning the steps it has taken to the prospect of further steps. The order heretofore entered by the Chief Justice is vacated.
Okay.
And so this is going to come up because the government immediately filed a motion to basically modify the schedule. The district court, after receiving guidance from the Supreme Court, basically immediately said, give us more information on what's going on. And the government filed, and in part, and it's basically just like 2 pages of the weirdest jurisprudence I've ever seen. I've never heard a government attorney take this tone with a court before. So the government filed a motion for a modified schedule. Everything will be in the show notes. Quote, defendants request the court modify its amended preliminary injunction to allow defendants reasonable period of time to evaluate the Supreme Court's order. Not to comply with anything, not to provide the court more information, just to evaluate. And what they're hanging their hat on in relevant part is that quote I read you from the Justice's order. The initial deadline contained by the amended preliminary injunction, which requires defendants to provide the court with a plan for diplomatic engagement a mere 30 minutes into the business day following the Supreme Court's decision, that this morning, April 11th, last night, is inconsistent with the Supreme Court's instruction that this court, quote, clarify its directive with due regard, emphasis added, for the deference owed to the executive branch in the conduct of foreign affairs. So basically they're hanging their hat and saying, you have to give us more time. It's very strange because the court did not order them to comply. They just asked for information.
Yeah, and they said that you must facilitate the return, right, with no concrete terms.
No. This is the district court.
Oh, my apologies.
District court requested information from the government saying what is your plans to reply, and in response they filed this
more time, please.
Yeah, motion. Well, not even time to comply, time to evaluate the order.
Wow.
Now, the Supreme Court's order was only about a page and a half. There was a parallel statement from the liberal wing of the court, but Justice Sotomayor, Jackson, and Kagan joining. But it is not a long order. This should not take a voluminous amounts of time for them to analyze.
Yeah.
And at the same time, attorneys for Mr. Garcia also filed a motion opposing the government's motion.
Saying they don't get more time to consider this.
Yes, plaintiffs, this is also this morning, props to their attorneys, also only 2 pages from Quinn Emanuel, a fantastic Jonathan Cooper doing fantastic there.
Nice.
Plaintiff's opposition to defendant's motion to modify schedule at 6:43 p.m. yesterday, the United States Supreme Court issued an order finding that this court, quote, properly required the government to facilitate Abrego Garcia's release from custody in El Salvador. The court further ordered the government to, quote, be prepared to share what it can concerning the steps it has taken and the prospect of further steps. Last night, this court, meaning the district court, ordered the government to file no later than 9:30 a.m. today a declaration from an individual with person's knowledge, quote, addressing the following. 1, current physical location and custodial status. 2, what steps, if any, the defendant have taken to facilitate Abrego Garcia's immediate return. And 3, what additional steps defendant will take and when to facilitate his return. That's all the court asked for. And the government said, not enough time. We got to evaluate this page and a half order. Quote, this court's order to facilitate Mr. Garcia's return was issued 1 week ago. It was not stayed until Monday afternoon. Accordingly, the government should have been taking actions Friday, Saturday, Sunday, and Monday morning, and the government can report on those actions. The Supreme Court lifted the stay yesterday evening. Accordingly, the government should have been taking actions last night and this morning, and it can report on those. The government should likewise be in a position to tell the court in general terms what its further plan is to facilitate Mr. Abrego Garcia's return and who in the government is responsible for implementing that plan. Instead, the government continues to delay, obfuscate, and flout court orders while the man's life and safety is at risk. Its request for an extension filed this morning in defiance of the court's rules requiring consultations with plaintiff's counsel, that's also true, is another stunning display of arrogance and cruelty. Wow. It did not take that time to ponder whether to remove Garcia, which it effectuated within 72 hours of his unlawful seizure, and it does not need that time to comply with this court's and Supreme Court's rulings. We vigorously oppose the government's motion, and we further request the government immediately report on Mr. Garcia's safety and well-being.
Beautiful.
That was it was also a very short motion. It was only about 4 paragraphs.
That was most of it.
I just read virtually all of it to you. It'll be in the show notes. I think here, this reads to me like a court that's significantly internally divided. I think initially the Justice Roberts order staying certain aspects and saying, well, you have to give immigrants an administrative hearing at least before removing them. It was one of the classic examples of, like, in theory it helps, but it left the door open for the government to basically disappear people before courts can intervene, because they talked a lot about venue jurisdiction versus filing in Texas where you're held versus filing in DC. I think the big takeaway is that at least the Supreme Court has moved in the right direction here, and a win is a win.
Yes, absolutely.
A win is a win. What are your thoughts, Lindsay?
I think that this is a beautifully written motion. I love that the lawyer here, Jonathan Cooper, just plainly states this is arrogance and cruelty.
Yeah.
I really appreciate that he's not feeling the need to hold back. He's not walking on glass. He's just going for it. And he's stating what I agree is the truth here.
Yes.
And it's such a shame to see our government acting against this man in this way and being so arrogant and cruel.
Well, the interests of the government here are very clear. They cannot let him return, or else he will tell his story.
Yes.
Right? It's bad. This PR is bad enough for them knowing that it happened, but we have not actually heard anything from Mr. Garcia, at all.
It's been, 26 days?
Yeah.
Or something that he's been detained?
We have no exact information from him. And so this would be really bad if the federal government allowed his return and allowed him to talk to the media now that he's not in a El Salvadorian propaganda prison. And so it's no surprise to me that the federal government is trying to stop this, as unfortunate as it is. Politically, it's advantageous for them, and law is politics.
That's true.
That's why we talk about it so much on this show. I think the next steps is I expect the district court to be rather cross, but I think the judge I think will be hesitant to drop the hammer too quickly because the court knows that the Supreme Court is watching very closely.
Yes, very closely.
From the Chief Justice's administrative order staying the temporary restraining order, we're demanding his return. I think it was on April 8th at midnight, April 7th at midnight. Initially, the Supreme Court stayed that order. That was a strong signal to the district courts that need to tread carefully, that at least though this initial order demanding his return is unanimous, there is clearly ideological support for the government's position. And so I think, what's this judge's name? Zini, I believe it was, or something like that.
Paula Zinnis.
Zinnis, excuse me. My apologies. It's with an X.
That's a cool name.
Yes, that is. I think Judge Zinnis is in a really tough spot here because it's a white hot spotlight. Being a judge is hard enough, particularly at federal practice, particularly before, I believe this is in the District of Maryland. Yeah, this is in the District of Maryland. I think we'll have to see what the court does. I could not have predicted half of this stuff, and neither of any of the jurists that I've talked to. I think Legal Eagle did a video on the initial Supreme Court order.
Nice.
And then a lot of his conclusions fell apart because the very next day after he put out the YouTube video, the Supreme Court dropped this unanimous decision. So this is pretty crazy. We'll put the request from the court at 9:30, on Friday evening was very short, but we're going to put all the substantive stuff, which is to say the government's motion, Quinn Emanuel's opposition, and the Supreme Court order will be in the show notes. I encourage you to read it yourself. It's very easy to read.
Yes, it is.
And I think I will leave everyone with an excerpt from the parallel statement from the liberal wing, which came out concurrent with the very short page and a half from the unanimous court. There's a pretty stinging rebuke written by Sotomayor in the longer part of the administrative order today from the liberal wing, as I've said, and I'm going to read you a particularly poignant portion of it that I think is very telling.
Please do.
Quote, "The United States government arrested Kilmar Abrego Garcia in Maryland and flew him to a terrorism confinement center." That's CCOT. It's an El Salvadorian complex in Salvador, where he has been detained for 26 days and counting. To this day, the government has cited no basis in law for Mr. Garcia's warrantless arrest, his removal to El Salvador, or his confinement in a Salvadorian prison, nor could it. The government remains bound by an immigration judge's 2019 order expressly prohibiting Mr. Garcia's removal to El Salvador because he faced a, quote, clear probability of future persecution. So he was a lawful resident there and, quote, demonstrated that El Salvador's authorities were and would be unwilling or unable to protect him. The government has not challenged the validity of that 2019 order. Instead of hastening to correct its egregious and admitted error of deporting Mr. Garcia, the government dismissed it as an oversight. The government now requests an order from the court permitting it to leave Mr. Garcia, a husband and father without a criminal record, in a Salvadorian prison for no reason recognized by the law. The only argument the government offers in support of its request is that the United States court cannot grant relief once a deportee crosses the border is plainly wrong.
Yeah.
The government argument, moreover, implies that it could deport and incarcerate any person, including U.S. citizens, without legal consequence so long as it does so before a court can intervene. That is very eloquently put, and the exact problem with the Chief Justice's order issued on, I think, April 8th. Crazy stuff.
Crazy stuff.
April 8th or April 7th.
I want to add at the end here, the lawyer who admitted in court that it was a mistake that the government deported this man to this prison. He was asked in court and he said, yes, this was a mistake. This shouldn't have happened. That lawyer's name is Erez Ruveni. He had recently become the acting deputy director of the Office of Immigration Litigation, and he has now been suspended because he admitted that it was a mistake that man was deported.
Yes, so
which is just crazy to me.
Pam Bondi put out a statement saying he was suspended for not zealously advocating for at what the Supreme Court thinks is baseless and lawless actions, which is what you're supposed to do. Is you're supposed to admit and have candor before the tribunal as a practitioner. He was defending his bar license.
Yes, and he was suspended from his job for it.
Well, it's no surprise that they have had trouble finding the fact that he's deputy director. Has been a huge shakeup at the DOJ. That they have no people left to fill the ranks who are cowardly or stupid enough to fall in line does not surprise me. So we'll just have to keep an eye on this as it unfolds.
Yeah, we will definitely be keeping our eyes on this, folks. Let us know what you think.
Yes. Go to gossipwithoutprejudice.com if you want to support us, like, follow, and share. Send this to one person you respect. We really want to try and spread our message and our analysis to as many folks as possible. Sponsored by Hemmat Law. We're here from Hemmat Studios. And also thank you to our sponsors, Quimby Bar Prep. So you're going to be hearing more from us in the coming days, and we will see you very soon.
Thank you so much. Bye.